I see that we have one of our other special guests also here, Latrina Kelly James. Latrina, can you say good morning just to check to see if your sound is coming through?
Good morning, everyone.
Great.
Sounds good? Okay.
Very good. Thank you.
You're welcome.
Well, Jasmine, it's still a little foggy, so if we can get that telephone connection, that might be best. Well, let's do this. For the members that can hear, let's get started on this morning's agenda. First, we'll start with a general good morning to everyone. We're glad to see that our co-chairs are here with us, Justice Earls and Attorney General Stein. Good morning. We'll start with the number one item on the agendas. We have prepared and distributed the minutes from last week's meeting. Are there any questions or concerns with respect to the minutes of that meeting? No questions, no flags raised. Is there a motion?
This is Mike. I move we approve the minutes.
Thank you. Is there a second?
I'll second.
Thank you. All in favor? Aye.
Aye.
I think that motion carries. Thank you. Well, this morning, we've got both a full agenda, but also an agenda that will permit us to have, I think, meaningful conversation. So there's time in this morning's agenda for the working group members to do some debriefing generally, most especially to do some follow-up discussion on the remarks of our two special guests. We have Jasmine Corbett, who Mary Pollard and I know as a remarkable young lady and a former client. For many of us, our clients are never former. They are clients and friends for life, and Ms. Corbett falls into that category. We're familiar with her experience and her story, and we're hoping that her experience will give some richness to the discussions the working group has had with respect to mass incarcerations, the difficulty of extreme sentencings, the difficulties that occur when there are pockets of discretion in the criminal justice system, and how that discretion is exercised. And we also have Latrina Kelly James, a very experienced advocate who has worked for many, many years in the space that services harmed parties. And most importantly, she's given a lot of thought to this notion of harm and how harm reduction is and should be the appropriate goal for the criminal justice system, and how the system as it currently operates misses that mark. Yeah, how can we do a better job at identifying levels of harm, individuals who are harmed, and appropriate paths for healing and making stronger the people, the individuals, and the communities that are harmed. So after Ms. Corbett, we'll hear a presentation and a facilitated conversation by Ms. James. And I think there's going to be a wealth of insights that come out of both conversations, and we'll be looking to Michael Robinson and Karen Dwyer to help us parse through some of what we've heard this morning. I'll note that with Ms. Corbett, I think in a socially distanced way is her attorney and my co-director of North Carolina Redress. There she goes, Cindy Adcock. And Cindy Adcock is not really muzzled, but there is a mask there. We probably won't be hearing much from her, but she's there to help facilitate the conversation if that's helpful. Otherwise, Jasmine, please take this opportunity to address the working group. We have been assembled by Governor Cooper to examine the criminal justice system and to explore ways that that criminal justice system can operate more fairly, most especially with respect to the treatment of the African American community here in the state of North Carolina. So Jasmine, please tell us about your experiences and share that.
Can you hear me now?
I can now. Yes, indeed.
Okay. Hello. Okay. Hello, everyone. Good morning.
Good morning.
I just want to first thank Attorney General Stein for letting me be a part of this, and Henderson Hill and Miss Mary Pollard. I just want to thank y'all so much for everything y'all have done for me in general. But well, to tell you, I know y'all already know things about me. So to tell you just a little bit more, I was 17. I was into an abusive relationship at the age of 16, and I was with this guy, and you know, I always had a job since I was 16, but I had got with him, and it was very abusive. I still have marks on my body to date from the abuse that I suffered at the age of 16, and I'm 29 today. But he got into the drug game, and I got me fired for so many jobs, and the abuse, the scaredness, I ended up doing it with him and end up making a horrible, bad mistake. And to end up going to court and never knew the significance of what I was doing. I didn't know it was that harsh or whatever. I was getting in that much trouble because I didn't understand the justice system. Nobody in my family has ever been to the justice system. So to catch charges and then to go to court and then being convicted of 17 to 21 years as a 19-year-old with a newborn, it was just unbelievable to me. Like I couldn't understand it. I didn't understand why I got so much time when all my co-defendants didn't. But it happened, and so I went to prison. And, you know, when I got to prison, and just to see that people of different ethnicities and different backgrounds having the same charges I have and getting less time than me, and they have been in trouble before, and, you know, me never been in any trouble, and getting sentenced to 17 to 21 years, it was just mind-blowing. And to have to go through that, and my child, him suffering, because like I say, he was 8 months when I got locked up, and I stayed in prison all the way up until he was 10 years old. And so, like, me being out now, we learning each other again. It was just very difficult, and something really needs to be done about this, the over-sentencing.
Thank you, Jasmine. I wasn't exaggerating when I described you as remarkable, but you decided, or you explained how you made some mistakes. Tell us the crime that you were charged with. What was that crime?
I was charged with 3 counts of drug trafficking. They broke it up, possession, sale, and delivery. I was convicted of 5 to 7 years for possession, 5 to 7 years for sale, and 5 to 7 years for delivery for drug trafficking.
And were these, was the drug itself, were they pills? What was the drug that you were convicted of selling or trafficking?
They were pills. MDMA is what they were called. What they were called on the court docket, I guess you can say, or what? That's what it's called. No, I've never seen those kind of drugs before. I didn't know anything about drugs, you know. Yeah, I just rode with someone. I didn't even know what was in I just literally picked up the box and passed the box. I never looked in it. I never knew what was in the box. I just literally that's what that's my crime of picking up a box from a car and getting in another car and giving the box to someone else. I never looked in a box. I never even know what the drugs looked like until in court when they had it laid out on the table.
Yeah. And did you know the person that you were selling? Did you come to meet the person that you were selling the drugs to, find out who that person was?
Yes, it ended up being an undercover. I haven't met him before then. He was dealing solely with my boyfriend at the time. My boyfriend had got locked up, and he was like, when he got locked up, it was a breath of fresh air, first of all. But then it was like, well, you better do this, because if you don't do it, then you know I'm not going to be in here forever. And, like, you know the consequences. So even though I didn't want to do it, I did it because of the consequences. He told me what to do. Like, this guy is going to call you. This is who you call. This is what you do.
Thank you, Jasmine. I'm going to ask Cindy, who's sitting there next to you, if she had any observations that she wanted to share with the working group about the experience that Jasmine went through.
Yes, well, thank you again for having us. So at first, when we got, in fact, Mary Pollard's organization sent us over Jasmine's case because they thought it was very compelling. And at first we're like, I don't know, 20 years, what's 20 years, But then you start digging into it and you saw how little she did, how young she was, the abuse that her attorney knew a little bit about, but really did not know the depth of the abuse because she didn't really appreciate, that she was an abused girl really at that point. But and then her son, it was just so compelling to think about the consequences. If we could get her out, he would be 10. If we could not get her out, he might be 20. And the difference between her son not having a mother or a father for those 10 years was significant, particularly since he was living with her mother and their family. You want to talk about that a little bit?
Yeah, my son was living with my mom, was also living with my little brothers and sisters. It was 3 of them, and my nephews, is 5 of them. So, he never had his own room. He never knew what it was like to be by himself. There's always someone there. So, but now he got his own room. So I'm so excited. I never want to leave home. Yeah, he was struggling really bad in school. Like, we had to work on that during the summer. That was a difficult time because it was like we learning each other all over again. I'm trying to learn him and trying to be a teacher at the same time. But we got it together. With the help of Beth, too. We got it together.
It's wonderful that you're in a position now to take advantage of the help that your family, your aunt, your cousin have stood by you and have supported you for these many years, and you're able to see the growth in your son these several months. Well, thank you for sharing. I hope you're able to stay with us. What we're going to lead now into is a discussion of this larger frame about how the criminal justice system should look beyond the numbers. It should look towards the larger picture of identifying harm and how we can best reduce harm and build stronger communities, stronger families. Latrina?
Thank you, Henderson, and thank you, Jasmine, for sharing your story. It is an honor to come after you. So just thank you for being with us this morning. So thank you, Henderson, for bringing me on. So I have been doing this work around survivors and the criminal justice system for many, many years, and what it looks like to center the experience of survivors in that work. I am a survivor myself of violence, and the ways in which violence and victimization and the criminal justice system and offenses are not necessarily separate, but intertwined. And Jasmine shared with us very, I think, eloquently about the ways in which her victimization and the way that she was victimized in the system are intertwined. And so I'm going to share just a short presentation with you all this morning about the ways that this shows up in terms of racial equity, particularly for this task force. And I'm going to share my screen, so give me a moment here. Can everyone see that? Can I get a thumbs up? Okay. Excellent. So when we talk about harm, race in the criminal justice system, what we know is that no one enters an equitable justice system. That's the reason why you all are in this task force and working group, right? And race plays some kind of factor in how the justice system interacts with Black people and people of color. What we don't talk enough about are the two ways that people enter the system, both as a victim and as an offender, and what connects the two and gets at the root of these racial disparities that we're trying to tackle here in this task force. It's trauma. And when we talk about trauma, we mean a series of events or circumstances or things that have happened that physically, emotionally have harmed or been life-threatening, and the lasting effects of that. Sorry, let me go back.
Latrina, I should
Yeah.
tell you that I'm not seeing a shared screen. I don't know if others are, but it's not appearing as shared on my screen.
Can others see it?
I can see it.
I
Yeah.
can see it.
Okay,
Yeah,
so
I can
please
see it.
continue. Yeah.
Okay. So trauma has lasting effects on someone's physical, emotional, or spiritual well-being. And everyone experiences some form of trauma, no matter who we are. But what makes it different when Black people and people of color have trauma and enter within different parts of the justice system? There's racial trauma, which really refers to race-based stress, the stress of events or perceived experiences of racial discrimination. And that's anything from the threat of harm to humiliating events to witnessing racial discrimination towards other people of color. And that can include the watching of videos of Black people being killed by police over and over on social media. It can include reading about racial trauma and experiences of racism. And the historical trauma is the collective emotional and physical wounding of communities over a lifespan, and it crosses generation after generation. What does historical trauma look like? Things we know, right? There's slavery, lynching, convict leasing, destruction of people and land, the spectacles of Black death. And I put this up in particular because this is a key historical moment in North Carolina history of Wilmington being taken over and seized and Black people killed in the streets in the 1890s. That is a historical marker of historical trauma. Although you may not have lived it, it is remembered, it is ingrained in the blood, in the memory of people. They experience it in very implicit ways. And racial trauma can look like anything from what we're talking about, right? Disparities in sentencing, knowing that you're coming into a system that is lopsided, being stopped and harassed by police at higher rates, a lack of access to supports and services when you are victimized, and the spectacle of death. And I talked about the viral videos of Black people being killed by police. Those things being seen over and over again have an impact on how people see themselves and how the people who are interfacing with them see those people as well. And when we talk about the spectacle and the dehumanization, that's what we're really getting at. We're talking about the dehumanization of Black people when they enter the system and how the system in itself can be harmful because of that dehumanization. So if you think about the historical and racial trauma that folks may face in being dehumanized or remembering and hearing the stories of dehumanization of Black people, that is not ingrained also in the folks that are now interacting with people that have that racial and historical knowledge and memory of historical markers of trauma. But the data shows us that what it does is sees Black people in a different light. No matter who you are ingrained, it is trained to see Black people as different. In a 2014 study, looked at the dehumanization of Black boys. Participants in the study were more likely to rate Black boys as less innocent than white or Latino boys, particularly when boys are matched with serious crimes. And then there's the adultification of Black girls. Nationally, Black girls are suspended at more than 5 times the rate of white girls. Black girls are 2.7 times more likely to be referred to the juvenile justice system than their white peers. And so going into the system already, or as they're walking as they're in school, as they're interfacing with different actors across the system, there's already set up to be seen as different and less. Ooh, let's go back. So no one enters an equitable system. Black people and people of color don't enter an equitable system because they're not humanized in their experiences. And we know there's 2 ways to enter, and we said as a victim or as an offender. What happens when you enter the system as a victim? It means that you don't get more services and support. The Federal Office of Victims of Crime put out a study in 2019 that looked at the victimization and access to support and services for victimization and trauma across communities, across race and ethnicity. It found that Black males under the age of 35 who lived in urban households with incomes under $25,000 were more likely to experience serious violent victimization, but 15 times greater than that of females aged 55 or older, living in non-urban households of 75K or more. But annual VOCA assistance program data, and VOCA, apologize, it keeps jumping. VOCA assistance is a federal program that provides funding to states and funding to service providers to provide services and support and healing supports for victims of violence and other crime. The Federal Office of Victims of Crime measures the data annually, indicated that 72% of those dollars for services for victims go directly to serving female victims. So 53% of the victims who are white, and a wide margin serving ages 25 to 59. So that means while Black men are 15 times at a greater risk of victimization, 72% of the dollars that go to states to support victims of crime and violence go to white female victims. So what does that mean for us? It means that as we're thinking about the ways that victims and offenders enter the system, they're entering the system in the same ways as a victim, under the umbrella of racism that this task force is tackling, but also under the umbrella of racial trauma. And racial trauma being not only inflicted upon Black people within historical aspects, within what they know, but also by actors in the system. So even if you are a victim and enter the system as a victim seeking services, you can be viewed as a cause for your own victimization. You have a lack of access to culturally competent victim services because you're not viewed as being a victim. There's no clear path towards healing, and you're not seen as human. Now, if you're an offender or harmed someone and you've entered the system, you may have been a victim. And Jasmine talks so beautifully about her experience of not only being someone who was now on the offender side of the criminal justice system, but who had been harmed and was being victimized within it. She talked very little or nothing at all, Jasmine, about actually getting support and services for the abuse that she was facing. It's unaddressed trauma and the personal experiences of racism and various system actors and not being seen as human all play into how Black people entered the system, this criminal justice system. And so if we look at this diagram, these circles are not exclusive, they overlap. And so victims or survivors are also folks who may have been harmed. And what we fail to realize in the work that we're doing around offenders and sentencing is that inequitable sentencing and extreme sentencing is rooted in one, dehumanization, and not addressing and using trauma as a factor in how we address those who've harmed. For victims and survivors, it means re-traumatization from the lack of support and acknowledgement of experiences, unaddressed trauma as well, and a threat of retaliation. So when we say a threat of retaliation, if you're not getting the support and services that you need to heal from that, there's anger, there's hurt, there's sadness. And so the threat of more violence and more victimization, either victimization happening to the person or that person then victimizing someone else and retaliating against the person that's harmed them, the rate is much higher. And within that, we see racism, racial trauma, and the same theme across that, not being seen as human across experiences and interactions. So as we think about the ways that offenders come into the system, are we factoring in the ways that they're not seen as human, their experiences are not being shared within different entry points of the system, from when they are arrested, from when they are charged, from when the district attorney decides on the fate of charges, all the way up to the judge and jury and sentencing. Are we looking at the whole picture? We need to see the picture of a person, including the system's role in that person's story. And so when we think about that, what I would love for this task force to think about is how you look at addressing racial equity in the criminal justice system from a trauma-informed approach. And what that means is safety. So when people enter the system, whether they're an offender, whether they're a victim, that they feel safe in their interactions that promote a sense of safety, and understanding that safety is the highest priority. So I will give you an example of what safety looks like on the victim side. My own personal experiences of violence. I was held at gunpoint in the early evening in July 2005, robbed, everything taken from me. When the police officer came, the first thing he didn't ask me was, are you okay? Are you safe? The first thing that was asked is, what were you doing with that amount of money? What were you doing out this time of evening? What were you doing? What were you doing? My colleague, who's been in this work around victim services for a very long time, white woman in San Francisco, had a similar experience of being on her bike home in San Francisco one night, was robbed at gunpoint as well. She was, at first thing she was asked, are you okay? Are you okay? Can we take you home? What do you need? That disparity and just how the interactions happen at your first point of entry into the system, whether you are the offender or the victim, matters. And race is at the foundation of that. Trustworthiness and transparency, that the decisions conducted across the system have a goal of building and maintaining trust. And that means factoring in and creating safe spaces to have conversations and understand the whole experience of people and Black people entering the system. And it means mutual help and support in building that trust and enhancing collaboration across the systems. Cultural, it means collaboration and mutuality, partnering and leveling of power differences. So healing happens in meaningful sharings of power and decision-making so that everyone's playing a role in trauma-informed approach. And that means all the actors in the system are playing a role together, from the district attorneys to the public defenders, to the police, to the judges, to the jury, to the victim advocates, are all playing a role in understanding the whole approach to decision-making in the criminal justice system. And that is not a linear process. And empowerment, voice, and choice, that the individual's experiences are recognized and built upon, and that we believe in the resilience and ability to heal and promote the recovery of trauma. We have to understand the ways people have been historically diminished in voice and choice. And thank you, Henderson, for honoring this approach by bringing Jasmine on to share her story, because I think the storytelling and understanding is deeply important. And then incorporating the policies and protocols and processes that are responsive to racial, ethnic, and cultural needs. And that addresses historical trauma as a foundation of how we go into decision-making across the justice system. And so if you go back to this circle and we look at victims and survivors and those who've harmed, if we do it from a very trauma-informed approach and understanding racism and racial trauma still at its foundation, what it looks like for survivors is safety and acknowledgement on the forefront of historical trauma and racial trauma as actors in the system interfacing with survivors of color who've come into the system. It means creating access to culturally competent healing supports. And that means not just the established victim advocates or victim services that are out there. There are peer support services available in communities that specifically target Black and people of color that will provide the services people need and peer support, folks that have been through similar situations that can help them navigate across the system. And voice and choice in how and where their people's healing happens. And for those who've harmed, it still involves the acknowledgement of historical and racial trauma as folks enter into the system, as they enter into being charged, and the decision-making that happens for that person who's coming to the system. And it is peer support. It's looking at ways to partner with those who've been across the system and had similar experiences, to provide restorative measures and to help that person heal as they're going through the system. Everyone needs healing within the system. And that the decisions are based on accountability, but are based on a holistic and human experience. And so that we're not discounting those experiences as necessary evils, as things that have happened to folks that play into the ways that they've harmed someone. But that if we're humanizing and recognizing trauma and recognizing racial trauma and experiences, we're able to create an accountability system that not only factors in that specific crime that someone's committed, but their whole experience. So what can this task force do as you're moving forward in this work? The acknowledgement of the stories and experiences of Black and people of color and the disparities in those experiences have to be shared out as part of the narrative and as part of the policy process. And understanding that victims and offenders are not mutually exclusive. And taking a trauma-informed approach as you're going into this process, as you're going into what the policies and processes and recommendations look like, and what the implementation of those will look like. And acknowledging that racial trauma is a factor in justice system responses and that it needs to be incorporated as a contributing factor in those experiences. And so I'm going to stop there.
Well, thank you. Thank you for that, Latrina. We're going to move to a facilitated conversation of what we've learned from Jasmine and Latrina's presentation. Before we do, I'm going to exercise one small short piece of privilege and say, with respect to the ingrained knowledge of history that Latrina talked about, I recently read Wilmington's Lie by David Zucchino that talks about the race war that was conducted on the Black community in Wilmington around the turn of the century. Folks don't widely know that, and in the impoverished community in Belmont, North Carolina, I'm sure they don't know the details of that. But the sense that they are part of a community that could be and has been taken advantage of by white supremacists is on the top of their awareness and their identification of current authorities as part of a continuum that goes back to that turn of the century is something that's ever present in their minds. And that's part of what we have to deal with when we talk about reestablishing racial equity as an organizing principle of our justice system. In any case, I think there's a lot of richness in what we heard. I especially am interested in Judge Thornburg's reaction to some of the details of Jasmine's experience, and to sort of pull some of that out. We're going to ask Michael from NCCJ to help lead us in digesting what we've heard this morning.
Thank you, Henderson. Good morning, everyone. Thank you so much, Ms. Corbett, Ms. James, for your compelling presentations this morning. Remarkable. We have about 20 minutes to discuss, and so I wanted to start off by asking if folks have any questions for Ms. Corbett or Ms. James before we go into thinking about context, how we might move forward from these presentations. Go ahead. Okay, no questions. We've had previous presentations along. There's a lot of data, a lot of numbers, and I'm curious to see in what ways do these presentations add context to that data that we saw earlier in presentations regarding racial disparities in long-term sentencing in North Carolina?
This is Mike. I'll start with just a comment that it depends on, for me, it depends on Jasmine's case is so incredibly, the injustice in Jasmine's case is so incredibly apparent. Are we portraying Jasmine's case as typical of the system, and that's why we are talking about it today, or is it being given to us as an example of how things can go horribly wrong? And are there things that we can do to protect against that?
That's a great question.
To that a little bit. I can say that I don't think it's all that much of an aberration. I had some history with this case before we went to Henderson, and when we took a run at it in 2014 or 2015, the DA we dealt with thought this was a totally reasonable outcome, and it's unfortunate. I appreciated Ms. James' presentation a lot. One of the things she talked about was the adultification, I think was that the word, of Black children. And, Jasmine was 17 years old, and the sentencing judge, with no prior record, and the sentencing judge referred to her as a one-woman crime spree or crime ring, and went on and on. And I don't know, the case, it's a particularly unjust case, but it's not all that much of an outlier based on what I think I've seen. Henderson might be able to add more context to that.
I will mention, I guess there are two issues that I see. One is the fact that apparently the story was not available or was not told, given the benefit of the doubt to the actors. But the whole story, and I think, as Ms. Kelly mentioned, I love the way she based decisions on accountability, number one, but also the human experience, the holistic experience. So that didn't happen, apparently. So the system failed from the beginning. And then number two, there's the issue of the glaring issue of the sentencing, the mandatory sentencing for trafficking. That's the very specific issue. And, most of you on the call have seen how that can play out. I assume it was designed to target, these big, scary drug dealers, but it can be used to punish an elderly woman from Madison County who sells her pain pills to someone for a used set of tires, actually. And that's because there are enough pills in that bottle. You make her a trafficker. Or for a young man, she mentioned MDMA, for one sheet of the stamp, the MDMA on them or whatever it is, that one sheet is a trafficking amount. And these are mandatory sentences starting somewhere around 7 years, mandatory $50,000 fine or up. And so those are charging decisions, but those laws are there and warrant some discussion.
I know we've had prior conversation about the role of discretion. And, in Jasmine's case, each of the 3 charges arose out of undercover buys that were determined by law enforcement. How much was being purchased, the number of pills, and what the sentencing response would be to that number. And it was completely within the discretion of law enforcement. Everyone else involved in this scheme was more culpable than Jasmine. But everyone else got a sentence under 30 months. And it is remarkable that you could have discretion work out so that the most culpable people had their crimes resolved in less than 30 months. And the least culpable gets a sentence measured in decades. And I think just the lack of recognition of Jasmine as a harmed party. There was evidence, Jasmine, about your abuse that the court heard. But there was a specific ruling that was not relevant to her guilt or innocence. And while that may be true in a legal sense, it was also seen as not relevant at the time of sentencing. And that's sort of fed to the sort of crushing result in the case. Any other thoughts about this experience and what we're wrestling with here, the working group?
Yeah, this is Mike again. So Latrina's comments about trauma and systemic trauma and historical trauma, that doesn't really tie in well with the sentencing guidelines that Judge Thornburg's talking about, right? Like in Jasmine's case, her sentence was upheld on appeal. The sentence was, and is that because you have these strict guidelines that you have to follow, or can judges take into account things like Latrina's talking about? Not just originally, but on appeal, review of sentences on appeal.
Judge Thornburg, you want to take a whack at that?
Sure. If I don't know her case, but if she pled to or was found guilty by a jury, it was a trial. Okay, found guilty of trafficking. There's a mandatory sentencing regime for that and mandatory financial penalties.
Judge Clark, do you have any comment on that?
Hi guys, I'm joining you a little late, so I missed Jasmine's presentation. But the trafficking, like Judge Thornburg said, as a defense attorney, I had problems with it. I never really represented a big time drug dealer. It was always the individual who was with no record, or perhaps record level 2, very minimal criminal history, yet the sentencing was, there's really no discretion is what I'm saying, because there are mandatory minimum sentences. You could have an offender with several convictions, drug convictions, charged with something lesser like possession with intent to sell and deliver, and their time is much less than a first-time offender charged with trafficking, and the amount of drugs is just above the threshold there. So there, in my opinion, it was never really fair when I was representing those folks. That's difficult to explain to clients when they see, you know, perhaps a co-defendant charged with something else getting probation when they're going to prison for an extensive amount of time. But that is the law, as Judge Thornburg said.
Well, remind me though, is there some limitation on the judge's ability to run these sentences concurrently? I know there is with, I don't have my book at hand. I know there are with certain habitual offenses, but, and so these were 3 convictions, right? Did they have to be boxcarred by that, like that, or could they have, at least 2 of them have been run concurrently? That was my understanding.
No, they could have been run concurrently. Remarkably, the district attorney did not ask for consecutive sentencing.
Right.
And so it was entirely discretionary upon the court how to run the sentences. And, you know, one of the things that we're wrestling with as a working group is the Second Look Act, and whether we should have some automatic right to for extreme sentences to come back before a court after a space of time, after a period of service of a sentence, to see whether it's appropriate or not. Because when we brought that same case back to the same prosecution office under new leadership, there was a fairly quick recognition that this seemed inequitable, and a fairly quick collaboration on how to redress that inequity. So I think it's a useful demonstration of the need and the appropriateness when the system operates with mandatory sentencings and things that can exponentially add to the length of a sentence. There should be valves, release valves in the system that permit adjustments to make sentences more appropriate, more fitting when there's additional information known.
You all are asking some really great questions and making some really great connections. And I wanted to think about this in the context of racial disparities. You know, Ms. James's presentation touched on race being playing a significant factor in these sentences, and perhaps something like, you know, Mary points out, this sort of stacking of sentences. And so I'm wondering what kind of questions folks have related to racial disparities and the impact that has on Black people, people of color in the criminal justice system. You know, based on the context we get from the presentation, but also, you know, in what we've had shared so far in the conversation back and forth.
Well, it's said that nothing is more American than baseball, motherhood, and apple pie. And what's remarkable is that Jasmine would have appeared for sentencing as a 19-year-old mother with no prior convictions. The sole parent for an 8-month-old. It's almost, you know, incalculable how a system could look at a young mother, the sole support for her 8-month-old, and think that it's right to separate her for a period of decades from that child. It almost goes without saying that the system can only do that if it denies the humanity of that mother and the humanity of that child. And I think part of what we've got to do as a working group is to say that this is a problem that repeats itself. And so the numbers that Ben Findholt shared many weeks ago about the disparities of extreme sentences visited upon African Americans, Native Americans, and white folks are grave, and it's a system problem. And we haven't quite figured out what to do about it. And I think that's a real challenge here.
So I hear from that, you know, how does the system see people differently based on race? You know, and I know we talked about implicit bias and things like that, but, you know, In this case, are they seen as human or not? You know, treated as such. What other questions do folks have, or thoughts or comments related to why the racial disparity exists?
I guess I have a question for the task force, this group, just about, as you're thinking about the different recommendations around the Second Look Act and so forth, are there, from what you've heard in this conversation, are there pieces that you can take into that would look towards policy? Are there ways that you can look at how a holistic experience and story plays into addressing the sentencing policies and addressing the current laws and policies in place? Like what would be your thoughts around addressing legislation around that, addressing processes around looking at the deep disparities in current sentencing for specific cases in the state?
So one thing I was thinking about, this is a little bit off track, I guess, but maybe not, is that, you know, a lot of folks have been trying to go back at the legislature and try to fix this trafficking weight problem we have and look at some of the problems with the mandatory sentencing for trafficking. And as I understand it, the legislature can't hear from our judges like Judge Thornburg and Judge Clark about what they see or what they perceive, because judges aren't supposed to talk to the legislature about it, which seems like a bit of an unfair handcuff on them, right? Because they see this in their courtrooms and they understand firsthand, I think sometimes they'd like to do something other than what they have to do by law. So I hope maybe their ability to speak as part of this task force would help inform some recommendations about those mandatory laws.
I would say that it's important to, and we've heard this morning, the importance of recognizing victims and defendants, the issues, the complex issues of both. We've heard from some of our public comments from the victim right, but it's all, many times it's all tied in there together, and hear from both and to honor stories of both. I think it's critical to have courts having enough information to make an informed decision. So my hat's off to presenters today for taking that approach.
I know I've heard from Latrina at greater length when she's had an opportunity to talk about harm and how people experience harm, both as the person causing harm and the person receiving harm, and how over a course of very young lives, people change roles repeatedly as being the harmed party and the person causing harm. And a system that responds only in the snapshot in response to an individual offense and ignores all that precedes and all that is to follow is a system that's going to miss opportunities to ensure public safety and to reduce harm. So I think this perspective, Latrina, that you offer is one that we need to spend more time as a system figuring out how to implement it. And I think what Judge Thornburg just said is exactly right. Listening to the richness of the stories of individuals who are both harmed and who cause harm is a way to do that. Yeah, I thank you, Latrina and Jasmine. This has been very, very helpful. We've been inundated with some of the numbers of the 34,000 people who are locked up in North Carolina prisons. We've been inundated about how the sentences they serve are broken up into X, Y, and Z categories. It was very, very helpful and meaningful for you, Jasmine, to bring your story here and for us to be helped in understanding the significance behind the decisions that the system makes, and where there needs to be improvement on what the system measures as it dispenses what we pass as justice. So thank you for that, and Latrina for expanding our view of response to violence. I think what I'd like to do is, I'm sorry, Michael, did you have some?
I did. I wanted to one of the things this brings up to me is thinking about how judges have such a heavy part of this, and one of the things that Judge Clark said that's kind of piqued this question that I have is, you said there's no discretion, right? The mandatory minimums, you have the weight, and it's technicality, so you got to push it through. And so I'm wondering then, what do you think? And this may be a question to think about later, right, in more depth. But what is on the side of the court? What is perhaps needed there to help, loosen some of that pressure, right? So that some of that discretion can be added, where maybe it's not, because and maybe some thinking around what are some of the things that, and I don't know if Judge Clark or Judge Thornburg want to speak to that, or want to take some time to comment on that, but I just wanted to add that piece in there for consideration.
Yeah. I think Judge Thornburg could probably speak better to this, but allowing discretion, meaning the law would need to change. Otherwise, discretion within the district attorney's office and the ability to offer perhaps a lesser offense for the defendant to plead. That's the only way I see something changing regarding this specific offense. Judge Thornburg, do you have something different?
No, I think that's right. The trafficking is, that's an easy one to point to. There are other areas, I assume, and Mary can talk about what's going on in the legislature, and maybe there's some other priorities that she has had. But I would just make a note that we need to be careful when we talk about the discretion, because we know why we have structures in it is because
right.
Discretion was arguably.
We need guided discretion.
More punitive, right? Yeah, guided discretion. Maybe.
Guided discretion.
I like that. So, but Mary, are there some other areas that you have focused on in terms of mandatory minimums and that sort of thing?
I mean, really, no. Last year or 2 years ago, I guess we were. I was working with a group of folks who were trying to address the trafficking laws, both in terms of the weight and the mandatory nature, because they're outside structured sentencing. They're one kind of funny. I'm less expert than I'd like to be since that time, but they need to be changed. The pill weight thing in particular, like Judge Thornburg was saying earlier, just a little bitty, a little bitty handful of pills is weighed the same for trafficking purposes as like a handful of heroin, right? I mean, there's no, I don't think anybody intended back when the law was drafted that pills would be treated like heroin, but that's where we are. So you'll have people serving extraordinarily long sentences for pill trafficking. So, and people caught up in it, like Judge Thornburg said, people who were addicted to their pain medicine, and then they start selling a little bit so they can get more. It's really sad. Some of the saddest cases we saw when I was at Prisoner Legal Services were the trafficking cases, in terms of length and relative moral culpability.
Thank you, folks.
Michael, I think what has come up from this last piece of discussion is discretion is a dangerous two-edged sword. And when we talk about racial disparities in the system, in large part, they grow out of all of the different pockets of discretion and how those discretions, how the exercise of discretion cuts against the interests of African Americans, people of color in the system. So part of what I think Latrina points to is the need for us to reframe the notion of justice. Is there something other than punishment? Is there metrics for justice that's different than the length of sentence? Yeah, is there a way of enhancing public safety that does not automatically translate into the longest sentence in response to a crime, whether it's a drug crime or a violent crime? And that requires, I think, what Latrina points to in her longer discourse about harmed parties and how the system recognizes the need to reduce trauma. And we will add some materials to the resource bank, so that's available to us. But again, we thank Latrina and Jasmine for bringing those stories to us. This has been a good conversation. I was hoping that we would reserve a good pocket of time, which is now reduced to about 8 minutes, to talk about some of the exchanges that we've had since the proposals have been generated on jury selection and on the clemency issue, and to really just do a temperature check of the members to see whether or not our offline processes have been working and whether people have had an opportunity to add to and to edit those proposals, and just see where our comfort level is on the drafts that are circulating. And I'll look to Mary. I know that you had some exchange on the internet that I saw. Judge Thornburg, you might be in a position to add. Mike, starting with Mary.
Oh, I worked yesterday and made some suggested edits to the clemency proposals that should be, I guess, should be visible to everybody if they click on it in red and track changes. I thought the jury proposal looked pretty good. I kind of ran out of time to spend on it yesterday, but I didn't have any significant suggestions related to that one. So thank you.
Thank you, Mary. Others? Mike, I know you had at one point some questions about our statement of the problems. I know I have not been able to look at that since our last conversation. You know, I think we still have some time to edit and to get comfortable with that discussion. So I guess my encouragement is to use the technology that Mercedes, Ellen, and folks are making available to us to actually see what our colleagues are doing. Yeah, I'm not the master of those technologies, but I will try to add to it over the next week. And I encourage everyone else to do the same. I think this is especially helpful because we are going to be moving into some of the knottier issues before our working group. And so being able to process and move recommendations that we do feel comfortable with, even as we don't spend as much time on those recommendations in the working group, is going to be important. So most especially on some of the jury selection stuff, I think we've spent some fair amount of airtime at the working group meetings on that. Let's try to do our best to knock out the remainder offline. I will say this about the fines and fees. We had a conversation that troubled me a little bit, and that part of our charge might include looking at some of the fines related to DWI offenses, and if Justice Earls is monitoring, I might have missed another part of it. That as I recall the discussion, we had not spent a great deal of time on those issues. And what I may do is try to review my notes and send to the group, but with a special plea to Judge Locklear Clark to take a look at that question and see whether or not we need to spend a little bit more time with respect to DWI fines, failure to appear, fines, and how the sort of repetitive nature of those fines and the growth of those fines are something that are especially debilitating to poor people and to people of color. And it's a slightly different take on the fine and fees discussion that we've been having, because our discussion is largely tracked on the court fees, not so much the fines. And there's a different impact on that. And it may be that the task force is looking to our working group to contribute to that conversation as well. So I'll look at my notes and do a better job of communicating that to the task force.
And Henderson, first of all, if you're Henderson, I'm Allen, so we need to remember that. I think we've given enough airtime to as you said, to the fines and fees, to the clemency issue. I'm still not entirely clear in my own mind. We have the COVID and we have the fair sentencing folks. So those are two issues. What role are we just looking at boosting the resources of the clemency office, or should we get a view from the parole commission and what their role could be with additional resources? I think we agree on the problem. I'm not entirely clear on what the most efficient method to deal with these two issues is if that makes so. I would be comfortable perhaps spending a little more airtime to put some clarity around that. So,
if I could speak to that just briefly, I addressed some of that with the revisions to the proposal, but I'm also, Jasmine and I spent some time talking with Angela Bryant at the Parole Commission, and she really had a lot of thoughts that I'm going to share in a separate document with the group offline, and we can certainly come back to it online. But she had some very concrete ideas about what they would need to be able to do their work in the manner they would like to do it. And it's, adding a parole commissioner, adding parole case analysts, getting some clearer direction on some issues, implicit bias training for the entire staff. So I've included some of that in my red lines, but I'll provide some more materials offline, and then we can come back online if we need to about it. So
that's very helpful. Thank you. Well, very good. I think we are at that 60-second spot. So I'll look around the table. If other members have an urgent matter to put on the desk, please do so now.
Just a brief comment. Last week, I mentioned the concern about convicted felons not being able to vote due to inability to pay fines and costs. And just last week, I believe there was a decision by a three-judge panel declaring that part of the law unconstitutional, which is a big win. So now it appears, at least temporarily, convicted felons who are on probation for the sole purpose of not having paid their monies may be allowed to vote, which is a good thing.
Thank you, Judge Clark, for bringing that up. I saw that. I thought that was a tremendously important decision, and thank you for reminding us of that, or letting us know about that decision. Excellent. I believe we'll call it a day. We wish Mercedes the best. She had a dentist appointment. I'm still traumatized by the thought of going to dentists, and I hope she survived it well, and will be back with us next week. And the business continues. Thank you so much. Have a great day and a good week, good productive week.
Thank you. Bye.